Hi, today I am going to present the case of Republic versus Claude A. Miller and Jumros E. Miller, GR number 125932, April 21, 1999. For the facts of the case, on July 29, 1988, spouses Miller, both American citizens, filed with the RTC Angeles City a verified petition to adopt Michael Magno Madayag, a Filipino child, under the provision of the Child and Youth Welfare Code, which allows aliens to adopt. The natural parents executed affidavits giving their irrevocable consent to the adoption, and the DSWD recommended approval of the petition on the basis of its evaluation. On May 12, 1989, the trial court rendered decision granting the petition for adoption. However, on August 3, 1998, the Family Code became effective, prohibiting the adoption of a Filipino child by aliens. Thus, the Solicitor General appealed to the granting of the petition for adoption by the RTC. The issue arises therein was whether or not aliens may be allowed to adopt a Filipino child when the petition for adoption was filed prior to the effectivity of the Family Code, prohibiting the same. The Supreme Court held, yes, an alien qualified to adopt under the Child and Youth Welfare Code, which was in force at the time of filing of the petition, acquired a vested right which could not be affected by the subsequent enactment of a new law disqualifying him. The enactment of Family Code, effective August 3, 1988, will not impair the right of the respondents who are alien to adopt a Filipino child because the right has become vested at the time of filing of the petition for adoption and shall be governed by the law then in force. A vested right is one whose existence, effectivity, and extent does not depend upon events foreign to the will of the holder. Vested rights include not only legal or equitable title to the enforcement of a demand, but also an exemption from new obligation created after the right has vested. As long as the petition for adoption was sufficient in form and substance in accordance with the law in governance at the time it was filed, the court acquires jurisdiction and retains it until it fully disposes of the case. To repeat, the jurisdiction of the court is determined by the statute in force at the time of the commencement of the action. Such jurisdiction of a court, whether in criminal or civil cases, once it attaches, cannot be ousted by a subsequent happening or events, although of a character which would have prevented jurisdiction from attaching in the first instance. Therefore, an alien who filed a petition for adoption before the effectivity of the Family Code, although denied the right to adopt under Article 184 of the said code, may continue his petition under the law prevailing before the Family Code. Adoption statutes, being humane and salutary, hold the interests and welfare of the child to be of paramount consideration. They are designed to provide homes, parental care, and education for the unfortunate, needy, or orphaned children, and give them the protection of society and family in the person of the adopter, as well as the childless couple or persons to experience the joy of parenthood. Give them legally a child in the person of the adopted for the manifestation of their natural parent instinct.